Hi, I'm Craig Kirshner, MBA, President of Kirshner Wealth Management, and I have been licensed in this business for over 25 years, and we specialize in working with retirees that have typically between 1 million and 10 million in net worth, and some of our clients have more than that, some a little less, but typically that's our specialty, 1 to 10 million in net worth. The things we have found is that they have special needs, distinct from other types of people with different asset sizes. And when you think about your finances, you want to think about your finances as a coin and two sides to a coin. One side of the coin is your lifestyle. We want to make sure your lifestyle is taken care of, make sure you can live the retirement of your dreams and really be able to achieve the goals you want to achieve in retirement. And the other side of the coin is your legacy, right? So you have your lifestyle, you also have your legacy, because most of our clients typically have children and grandchildren they love, and after they're gone, they want to leave those assets to their children and grandchildren. They want to keep the assets protected. They want to keep the assets in the family bloodline. So today, we're going to be doing a very special presentation on advanced estate planning, and we're going to talk about how to keep your assets protected after you're gone and how to keep the assets in your family bloodline for many, many generations. So let's get into it right now. One of the attorneys we've worked with for over 15 years is here, Jack Owen Jr. He's not only an estate planning attorney, he's also a CPA. He specializes in setting up trusts that are designed to help protect the assets you leave your children and your grandchildren from any future divorces, lawsuits, and creditor claims. His trusts are also designed to help keep your assets in your family bloodline. Now, the little voice in the back of your head, the one that just said, "What little voice?" is probably saying, I have a trust or a will set up, and I'm not an attorney, but your attorney might have told you you have trusts set up that are designed to protect the assets and keep them in your family bloodline. What Jack's going to talk about in a few minutes is that 9 times out of 10, your trust doesn't have these provisions. It has certain provisions that negate these provisions. Just what we see many, many times, and Jack will talk about that. Jack can help improve the quality of your estate plan because planning your estate can be difficult. Many people often have complicated family circumstances. I used to say I should write a book with all the stories we've heard over the last 25 years. I've actually learned from my dad, who's been in this business now for 46 years. And so, but I'm proud to say that I have written a book, and it's called Retire with Confidence, Preserve and Protect Your Wealth and Leave a Legacy. So we do talk about advanced estate planning in that as well, along with many retirement topics that are important to our clients. There are people with a daughter-in-law or son-in-law they just don't like. I've heard that 1 or 2 thousand, maybe million times. Jack can help with an estate plan that's designed so the assets you leave your children never go to that daughter-in-law or son-in-law after you're gone. We actually call those people outlaws at that point, not in-laws, right? There are people who might have a child who's a terrible spendthrift or an alcoholic or an addict. The trust Jack Owen sets up can help protect those children. The majority of our clients want their assets to go to their grandchildren after their children pass away. The trust Jack Owen sets up can help keep your assets in your family bloodline. In a few minutes, Jack is going to discuss how a Dynasty trust is designed to protect the assets left to your family. So let's say you're a husband and wife, for example, everything's for each other first, and then after you're both gone in this example, let's say you have a daughter and a son, right? And as Jack will discuss in a few minutes, again, I'm not an attorney or an accountant, but Jack is. He'll discuss this specifically. But in a big picture, let's say you want to leave 50% to your daughter, 50% to your son. You leave them to them in bulletproof trusts that are designed that your daughter or son can control their own assets. But these trusts are designed to help keep your assets divorce protected. These trusts are designed to be lawsuit protected and creditor protected, okay? Then, after your daughter or son pass away, let's say your daughter passes away, the money in her trust that's left in her bulletproof trust doesn't go to this daughter-in-law or son-in-law. It doesn't go to a charity. It has to go down to your grandchildren in the same type of bulletproof trust set up to ensure that your grandchildren are protected, again, from divorces, lawsuits, creditor claims. So they stay in your bloodline for many generations, and they're also designed to be protected for many generations from lawsuits, divorces, creditor claims. Lastly, regarding bloodline planning, let's say your son here doesn't have children of his own and he dies and he has assets left in his trust. His assets don't go to the spouse or go to charity. They have to go back to your daughter and then down to your grandchildren. So they stay in the family bloodline. Again, this is typically what our clients want, but 9 times out of 10, as Jack will say, you don't have these provisions specifically in your trust or will. Now, you can generally tell the quality of an estate plan by the weight, okay? So we like to have a little fun with this stuff. It's a little boring sometimes, but this is the type of an estate plan that Jack does, and you can generally tell the quality of your estate plan by the weight, right? Also, if your estate plan is more than 3 years old, there have been significant changes in estate planning laws just in the last 3 years. So it's probably a good time to review your documents, make sure they have all the latest provisions, all the latest IRA provisions, so you can stretch that IRA out for your children and grandchildren. Again, you need to have the IRS, as Jack will talk about, need to have the special provisions in there to make sure that your IRA can be protected for your children and grandchildren and be stretched out over their lifetime. So that's another advantage to a properly designed dynasty trust. So that's how a trust is designed, a proper estate plan, dynasty type plan. Now, our clients receive credit card shaped USB cards to carry in your wallet that have copies of all your legal documents on them, so you can carry these important documents everywhere, give additional copies to your children. And what it looks like is this. The data goes on this card, but in real life, it's literally the size of a credit card. All your legal documents are copied securely on this card, and you plug this in the computer, you have copies of all your legal documents right here in your wallet, right? A little size of a credit card. We often recommend, since your children are probably your backups, to give them a copy of this card so that if there's an emergency, a healthcare emergency or something, they have copies of your documents. They don't have to run around trying to find them, wherever they're kept, right? There's nothing personal on this card. Your documents don't say how much you have or what your assets are. All it says typically is that after you're gone, you want your assets to be split evenly amongst your children in bulletproof trusts. So nothing confidential on this card, but it makes it easy for our clients to travel, bring their cards, their legal documents with them. It has our contact information, so in case of emergency, they know who to call first to make sure your estate is well taken care of, to keep the cost low, make sure your family gets what they want and need and deserve in a very short and timely manner, as short as possible, right? Okay, I'm now very pleased to introduce Jack Owen. He's an attorney and a CPA. We've worked with Jack for over 15 years, and he specializes in advanced estate planning. Now, many attorneys do estate planning. They might dabble in it a little bit, or they might do it a lot. But what we found is that there are very few attorneys in our experience here in the Boca Raton and South Florida area that really specialize in advanced estate planning and make sure you have these multi-generation documents. So again, most of the time that's what our clients want. 9 times out of 10, as Jack will discuss, it's not really what you have. Jack earned his law degree from the University of Florida, where I got my degree from. He graduated with honors in the top 10% of his class. He's been a practicing attorney since 1985 and a CPA since 1981, so he really knows his stuff on the law and the tax side. He owns his own law firm in Palm Beach. So let's welcome Jack.
Great, appreciate it.
You're welcome.
We'll review the will for a few minutes and the other estate planning documents just as an overall review. A will is a simple way to pass along your assets, but under the will, your estate will go through probate. And probate requires a public disclosure and of all your assets and your debts, and probate is expensive and time-consuming. In Florida, probate can take up to 2 years and cost as much as 5% of the assets. That's not all the time, but it could be that way, so we try to avoid probate.
And one additional thing that's important, let's say one of your children is counting on you for financial needs, right? And you're taking care of one of your children. The problem if you have your assets passed by way of will through probate is, one of the potential problems, is that might be tied up in the probate court for 6 months to 2 years, and if they need money from you on a monthly basis and all your assets are tied up, that's not a good thing. So you want to avoid probate at all costs. It's very expensive. And with all due respect to attorneys, attorneys write very slowly at $500 an hour when they're probating your estate. So you want to avoid that.
Good point. So how do we avoid probate? Well, a living trust can avoid probate. Most of you probably have a trust of some sort. That's a revocable trust. It's called both things, revocable or living trust. And the good news is no probate, no public disclosure of your assets, debts, or liabilities, and no delay in distribution. So that's why most of you probably have the trust in place. There's other ways to pass your assets on without avoiding probate, and one is the beneficiary designation. A lot of financial institutions are using beneficiary designation forms like your IRAs, where you state what the beneficiary will get and what percentage they'll get upon your death. And that does avoid probate. But unfortunately, this way of avoiding probate does not shield those assets from lawsuits, including divorce. And they're not bloodline protected. We'll talk about that for a minute.
Actually, one more thing about this. This is one of the most important mistakes we see in advanced estate planning all the time. And the problem is, let's say on your IRA or bank or whatever, you have payable on death, and you name your spouse as the primary beneficiary, and then you name your children as the contingent beneficiaries, 50% to your son and 50% to your daughter. The problem with that is you could have the greatest trust in the world that sets up all these great, bulletproof trusts, and they're designed to be protected for your assets, but when you name your children as beneficiaries and it goes directly in their bank account, it doesn't go into the trust. It goes directly into their bank account. And the second they have it in their name, if they get sued the next day, God forbid, or divorced the next day, there's a great chance that some or all of those assets could be lost to that creditor or ex-spouse. So that's why it's important to have a dynasty trust, as Jack will talk about, but it's also important, really important, to make sure all your beneficiary designations name that trust as the contingent beneficiary. So your spouse, if you have one, is the primary, and then the trust can be the contingent beneficiary, so all your assets go protected in those trusts.
And we have special provisions in the trust that protect those assets.
Exactly.
As Craig alluded to, we have a lot of clients that we see their estate planning documents, and about 90% of them have what we call the outright distribution plans. And that means that they go outright to the beneficiary at some point in time. And once they go outright to the beneficiary, that means that there's no creditor protection and there's no bloodline protection. And that includes the IRAs as well, because as Craig said, the IRA beneficiary designation or bank account beneficiary designation is just another form of an outright distribution. And those assets are completely exposed to the divorcing spouse, to all kinds of creditors. And as a story I always like to tell is I had a client that left money to her daughter in a trust, and it wasn't an outright distribution, it was left to the daughter in trusts. The daughter was driving along PGA Boulevard, a 6-lane highway, moved over one lane, knocked a motorcyclist off that she didn't see, and the motorcyclist lost his leg. The motorcyclist hired every kind of personal injury attorney you could imagine to sue the daughter, and I had all kinds of personal injury attorneys in my office going through the mother's trust, trying to figure out ways to get to the daughter's assets. And they concluded they could not get to those assets, so the daughter was able to protect those assets that she had inherited through the trust, the Dynasty Trust, and the motorcyclist had to settle for the insurance limits that the daughter had. So that's just an example. It doesn't have to be a divorcing spouse as a creditor. Your children can have creditors of all kinds, including a personal injury type of thing.
Sure.
Many of our trusts have outright distributions, but they're delayed. The assets are held until the children are a certain age. In this example here, most of the time this is what we see, where somebody might have something set up in a trust where 1/3 of the trust goes to the children at age 25, 1/2 of the remaining assets go to the children at age 30, and the balance go to the children at age 35. And that's just a fancy way of delaying outright distributions, but they are outright distributions, because as soon as those children receive those assets, subject to creditor's claims, subject to divorce, and not bloodline protected.
And lastly, if you could go back, the last point on this slide is important. Most of my clients are 65 to 80 high net worth individuals. Most of my clients' children are all over age 35 when they actually end up dying. So The problem is if they're over 35 and they have these kinds of provisions in the trust or anything like that, there's just an outright distribution plan. And so we see this, as Jack said, 9 times out of 10, not the right type of protected trusts.
Many clients have in their trusts per stirpes language, and all that per stirpes language means is that if your child predeceases you, then it goes to the grandchild or that child's child. And that does help somewhat, but that just means it's an outright distribution to the grandchild. Right. And it could be problems if that's the way it goes. We don't like to see the grandchildren get outright distributions because of their age and possible immaturity. And in Florida, the age of majority is 18. Other states is 21. And so you can keep the assets in trust until they're 18 or 21, but at that point you have to outright distribute them to the grandchild if you have that situation come up. So again, we like the Dynasty trust provisions that state that the assets stay in the trust where they have the protection.
Also, you don't want hundreds of thousands or millions of dollars to go to an 18-year-old, because what they do with your money, you'll roll over in your grave.
Okay. So what we see sometimes, I mean, a lot of times, just to rehash, is that the son or daughter receives monies outright, and then if something were to happen in a divorce or some situation of a creditor claim, then your assets that you're leaving to your children would be subject to the divorce claims or the other creditor claims.
And this, if you go one more if you would, please. Yeah, so the problem here, though, the big problem we see a lot of times is maybe not divorce, maybe you have the best in-laws in the world. You know, I've heard that story, it's possible. So let's say you leave $1 million to your son, and you put it in his name, and then he dies after that, and his wife, your now ex-daughter-in-law, inherits that $1 million because he's got a simple will or a trust that says, and I love you, Will. He loves his wife. Everything goes to his wife. The problem we've often seen is that when the $1 million goes to that wife, let's say she gets remarried, okay? She'll have a new I love you will that says, I leave everything to my new husband who she loves. And let's say she dies subsequently and leaves that $1 million and whatever it grows to that husband. Do you think when the husband dies, that $1 million is going to go down to your children that he has no relationship with, or his children? And that's one way we see how assets get disinherited from families when you have these outright distribution plans.
We see a lot of times where we need to try to help protect the child from himself, because the child's natural tendency is just to share with his spouse or her spouse anything that they might inherit. And many times what we see is that a lot of times they'll go and buy a house, and the tendency then is to buy a house with inherited assets and put it in joint names. And that's way that all of a sudden now that becomes a marital asset, and at least half of that value has just gone to the other spouse. So a lot of times clients will tell me, well, I'll have a conversation with my children and tell them to keep the assets separate so they don't become a marital asset. And what I've found in our experience is that doesn't work. It usually you need to have the trust. As long as it stays in the trust, then it doesn't become a marital asset.
Excellent.
And then just to reiterate, if a divorce were to come after an outright distribution, those assets would be subject to claims by the divorcing spouse, and we get that every day. We try to have our children talk about doing prenups, but it's hard to get the children to think about doing a prenup when they really have no assets, and the only asset they have is a possible inheritance from the parents. So by keeping it in trust, it's really helping the child have their own built-in prenup, and the child doesn't really have to do it.
Exactly.
And it's just, we see this too much, that our clients' assets are, once they go, they're exposed on their children to these messy divorce situations. So what we do is we recommend a Dynasty trust. It's just a fancy word for saying that it's a trust that can last for multiple generations. You put your children in charge of the money. They can be the trustee of their own section of the trust. We just have to have mechanisms built in that if there's storm clouds coming with creditor claims and that kind of thing, they can temporarily step down and appoint a new trustee while that storm is brewing. It can be a sibling if they have a good relationship, but we just put in the backdoor appointment provisions in there so they can appoint a new trustee during bad times. Otherwise, during good times, they control the money as if they own it. So it's just having the trust cocoon around those assets that give it the bloodline and creditor protection. And we need to, as Craig already talked about, the IRAs and account beneficiary designations, those need to be flowing through the trust as well so that you get the bloodline and creditor protection. And we'll show you how to do that if you become a client of ours. And remember that we can still make it where your children have complete control if you want that. If you have a situation where there's a spendthrift or possible addiction problems, we can have other people have it control if that's what you need for your specific situation. And if your estate is over 11.1 million or 22 as a couple, then there's special provisions that we can add to try to keep down those estate taxes. Every person now has an 11.18 million lifetime exemption, so that covers most people. But if your estate is over that, and as a married couple over 22.36, we have a lot of good strategies we can discuss with you to try to get the estate down to avoid the estate tax. The estate tax is still 40% over those amounts, so it's still something to think about if you have an estate that's over that amount. And if you're charitably inclined, we can help use that to further reduce estate taxes or just to help you with your charitable inclinations if you want.
Yeah, we have some very advanced charitable planning strategies. Let's say you have, for example, a stock that's highly appreciated. You want to sell it, but you don't want to pay the taxes, and you do care about charities. So there are some advanced tax planning strategies that let you sell the asset, pay no taxes, get a big tax deduction right now, take income from the trust for the rest of your life, and then whenever you die, whatever's left in the bucket goes to that charity of your choice. And it could even be a family foundation that your family could control after you're gone. So there's so many ways that we can help, whether you're a 1 to 10 million or over 11 or 22 million, have some really specialized needs. There are limited partnership planning we can do. There's LLC planning we can do. There's asset protection planning. There's so many things that having an excellent estate planning attorney and a CPA, and as part of our team really brings a lot of value to our clients. Again, we have especially in that area. So these are just some of the strategies we talk about. So if you're interested in learning more, come to one of our upcoming dinner workshops. We hold them at Ruth's Chris or Abe and Louie Steakhouse in Boca Raton or Fort Lauderdale. We recommend you have to call to register yourself at 1-800-807-5558, 1-800-807-5558. The seminars are held from 4:30 to 6 with dinner to follow, 4:30 to 6. Usually they're on Monday or Tuesday nights. And again, at Ruth's Chris or Abe and Louie's, we'll talk about advanced financial planning techniques, advanced estate planning techniques to protect the assets, and really protect the assets you've worked so hard to build so you can really have, confidence, financial confidence during retirement. That's our goal and most of our clients' goal as well. So again, you've got the team behind you, and just call 1-800-807-5558. Also, when you're at the dinner workshop, you can find out how to get a copy of my new book, Retire with Confidence. So we look forward to seeing you. Thank you so much for your time. Really appreciate it. Looking forward to meeting with you in person. Have a great day.